Hello everyone, Jackie Jones for the third module of Lecture 6 in Professionalism and Personal Practice. This is all about duties, and at the end we'll be talking about an ethical model that you may call upon in practice to solve any problems that you may have. So moving on to the overriding parameters that we work under, you need to be mindful of the new Australian Solicitors Conduct Rules that were passed in 2015. I'm not going to go through all the rules, but there certainly are some on the slides that I'll just highlight. Importantly, before you do anything else, you need to have an understanding that our first duty as legal practitioners is to the court and to the administration of justice. It goes back to that initial workshop of what does admission mean? We're not just going and getting a certificate to say you've completed a course. We're actually being admitted into a particular profession, but as an officer of the court. And it is above any other duty that we may have, and that's certainly set out in Rule 3 of our conduct rules. Some students are a little confused because they think that you have to be engaged in court process for your duty to the court to come into play, and that's not the case at all. It doesn't matter whether you are doing a transactional matter, whether you are in court process, whether you are dealing in a negotiation scenario. Your ethical standard, your obligation is still to act in a way as required by the rules, but our duty to the court and what that means is above our duty to anything else. And it actually is a real challenge to lawyers, particularly young lawyers, to explain to our client that our duty to the court is in fact above the duty to them. And you might want to think about how you would have a conversation with a client that, if required, that would be in a clear and concise way, and maybe something that you need to speak to a supervising solicitor when you start practice as to how they may deal with that issue. Because the reality of it is some clients want the envelope pushed. Certainly some lawyers are happy to push the envelope, but that goes back to the professionalism and your professional identity that we talked about earlier. And you need to have that duty to the client as the foremost of your consideration. In court process, we are subject to the rules of independence, avoidance of personal bias, and there's also Rule 17.3 about making submissions or expressing views, about conveying a personal opinion. And interestingly, if you're doing any criminal law, 17.4 of the rule is that you must not become the surety for a client's bail. I can't imagine why anyone would even contemplate that, but again, it's that situation of losing objectivity, getting too close to the client. Interestingly, I have posted online a video about court etiquette, and if any of you have been in the court system, you may have observed different approaches. Certainly in the local court, it's very common to hear expressions such as good morning. And I've been appeared in local court from the day of my admission. And certainly when you are regularly appearing in a local court, you become familiar with the magistrate becomes familiar with those who are appearing before them, and that degree of formality sometimes just is diminished. The best tip I could give to you is that don't get into the habit of saying good morning in the local court, because as you move up the court hierarchy into the district court, the Supreme Court, and then further into the Court of Appeal, etc., the formality is much more pronounced, and it is far better to adopt a process, an approach that is going to work for you in all courts, tribunals, and so if you don't sort of slip into the habit of becoming familiar. Well, and as I say, it's quite difficult, but that's the best tip I can give you. Slide 7 has a comment about formality that Justice Palmer made in Wilson versus the Department of Human Services. It's not that old, a 2010 decision. I've got the link there to OSLI, which might be of interest to those, particularly if you're thinking of going in and appearing in court and being part of that litigious process. The rule about a responsible use of court process and privilege in Rule 21 is one that you need to bear in mind, and that's being appropriately adversarial and being mindful of your obligations as a legal practitioner in signing documents as to a cause of action, for example, that you will need to consider if you are filing a statement of claim in the court system, because there is an obligation on you to be able to appropriately disclose that there is a cause of action. Now, one of the big issues in Assessment 3 is the importance of identifying the client, because of course we have a duty to the client, but we have to really unpack sometimes who that client actually is. Is it the person who is sitting opposite us? Is it a corporation? Is it a child? Is it someone who doesn't have the capacity, and how are we going to obtain instructions from that aspect? So it's the starting point. And so when you are thinking about your file note and letter assessment task, being assessment task 3, this is certainly a point that you need to have big flashing lights about who is the client, because that then feeds into what is the retainer, what are you being asked to do. The duty to the client in the Uniform Rules, and also the definition in the Act, is stated there on slide 10, and be mindful of that. Who's the client for barristers? Some of you might be thinking you're going to be called to the bar. Barristers nowadays do take direct briefs, not all of them, but in that case, well, the client is the one who is instructing them. In a situation that they're briefed by a solicitor, then it's the instructing solicitor who is in fact the client for a barrister who is a sole trader. It's the solicitor's sort of the stopgap between barristers and the public. Rule 4 is a very important one. You look there and you see that there's lots and lots of different aspects. You need to consider it, but overarching all of those matters that are stated there on Rule 4 is Rule 3. Go back to that initial slide about the overriding duty is to the court. So all of those things in Rule 4, being honest, courteous, act in the best interest of the client, avoid any compromise to integrity and professional independence, comply with the rules, all of these things have to be seen in the context that we are an officer of court. But don't forget the client and the importance of course, communication. We spent a lot of time talking about being an effective communicator in Lecture 2, so I'm not going to traverse that again, but again to highlight just how important that is, as it is to follow a client's lawful, proper and competent instructions. A bit of a flashing light there. Are they proper and are they competent? And of course, are they lawful? And this sometimes will require a solicitor to be challenged and to challenge the client as to where their instructions lay. Confidentiality is an important aspect, and one that the client needs to understand. Now, that's something to consider in your client interview. It's part of the criteria that the client is advised of confidentiality and what that actually does mean. There are rules, of course, on conflicts, former clients, current clients. I mean, we are a profession that is regulated, and it's essential for a solicitor in a law practice to avoid conflicts between duties owed. There are a couple of exceptions, and you can have a look at those in Rule 10.2 that can be useful. But I mean, I was talking to a girlfriend the other day who she'd had her own practice. She had seen the wife in a matter. She then merged her firm with another practice. That practice, in fact, had obtained instructions from the husband, or seen the husband and given him advice. It was about a year before the merger took place. Then after the merger, and then these parties, their marriage did fall apart, and they then went to the firm, and of course the firm couldn't act for either of them because of the conflict. Don't underestimate conflicts. Check them out. Have you acted for the other side in a transactional matter? Are you still acting for a company, for example? Important to have the flashing lights on. Duty to colleagues, and you can have a look at those slides. What I will say is that it's easy to communicate in an unprofessional manner. I mean, sometimes I think of a few of the letters that I've written in my time, and I think really, probably just pushing that envelope a little bit too far in a litigious matter. And I think it's very important that we do focus on a respectful way of communicating. And if you have a look at slide 17, that's an interesting example of when there was deemed to be professional courtesy about just responding to say that they hadn't received instructions. And in fact, this happened to me recently. I'm involved in a negotiation. My client was supposed to have got back to me on instructions about a particular aspect of the matter that is really to finalise it. The other solicitor contacted me. Had I heard from him? I said, look, I haven't, but I'll chase my client and see whether he's provided instructions for me. The instructions came that he was away. I immediately got on the phone to the solicitor and I said, look, I just want you to know my client's away. I've not got an opportunity to speak to him. When he returns to Sydney, I'll do so, and I'll let you know what instructions I've received in respect of that matter are. It doesn't take much to be civil and courteous, and what it does do is it feeds back into your professional identity and your professionalism as a legal practitioner. I'm just going to take you back to slide 18 and refer again to Hawkins and Clayton and others, because none other than Mr. Cummins QC represented my client Mrs. Hawkins in the trial at first instance, in the Court of Appeal and in the High Court. So there you go. It's not often that you get to mention a barrister for in relation to a High Court matter, and then also the same person for being struck off because of his conduct. I think it's quite funny. Okay. Public comment. I don't know about you guys, it just makes my blood run cold every time I see lawyers engaging with the media outside a courtroom. I think we need to be really mindful of what we say and when we say it. Those of you who may stray into family law, or some of you might be interested in it, there is an actual restriction on publication of court proceedings, and there's a penalty. So just be mindful of Section 121 of the Family Law Act if you do go into that area. I don't know whether maybe that rule that was introduced, Rule 28.1, was in response to prosecutors in criminal trials. I don't know, maybe you'd like to have a thought bubble on that and post a comment. Now, we talked about a model for ethical decision making, and that's there on slide 21, because it's always useful to have a guide or direction on how to deal with matters. It's not a matter of if you have an ethical issue arise in your time as a legal practitioner, but when. It still occurs to me and to every other legal practitioner I know, whether it is that a client is going to say something, or whether you have seen something, or whether there is something that is transpiring that you need to be mindful of. Now, what is important is that you don't think that this is in a vacuum, and that you need to deal with ethical issues on your own. That is far from the truth. There will hopefully be someone in the area where you are working that you can speak to, get guidance from. If there isn't, or even if there is always the ethics hotline through the Law Society. Please use it. I have used it on numerous occasions. It is a objective voice of reason that a person on the other end will get you to provide more information, unpack what you've seen, what you've heard, what your concerns about, why you're concerned about it, and then deal with it in a very systematic way to address whether in fact there is an issue. So as an example for you, I was involved in a matter one time. My client was in the witness box being cross-examined. I was at the bar table instructing senior counsel, and as I was going through various documents, I saw something in those documents that I was concerned about, and the basis of my concern was that it was conflicting with the information that our client had told us and that he had given evidence about in the witness box under cross-examination. When there was a break, I think it was a morning tea adjournment, I immediately showed senior counsel. I was a senior associate at Corrs Chambers Westgarth at the time, and I made 2 phone calls. I usually like to ask students, who do they think I called? Have a little think about it before I tell you who I called. The first call I made was in fact to the ethics hotline at the Law Society. I wanted to get some guidance on this, and just to see whether my concern was justified, because if we were going to withdraw while our client was under cross-examination, that was a pretty serious step to take. The other call I made was to the partners at Corrs Chambers Westgarth, for me to get a partner to come down and to make a decision as to what was happening. That's what partners are for. They've got the firm has professional indemnity insurance, and ultimately the partner needs to make a decision about that. Now, we didn't do anything after we explored what I'd seen and the context of it, because what we needed to unpack was this client was one that if he said it was raining, counsel and I would literally go outside and have a look to see if the rain was coming down. There was quite a degree of suspicion as to the validity of all comments and instructions that he gave us, and we were always poised to require evidence to support and confirm his instructions. So ultimately, we didn't do anything, and when his evidence was completed, we spoke to him and he was able to give an explanation that was perfectly justified. But please don't think that you deal with ethical issues in a vacuum on your own. Always go to a partner or a senior practitioner and use that ethics hotline. We have obligations to disclose costs to the client. Be mindful of section 174 with 1 and number 2, because clients have an obligation to be advised of what the likely costs are going to be. Look, it's really hard when you start out to actually give an estimate of costs. If you're having a fixed fee, that's fine, but if you're in a litigious matter, then it is quite challenging. So the best thing to do is talk to a supervising solicitor or a more experienced practitioner, because we have ways about calculating. But the important thing to note is that inevitably, as the sun rises, legal fees will change, because when you give an estimate of cost, you have limited information, and often matters do become more complicated than what initially they might have perceived. So have a look at 2, and also have a look at number 3 with regard to the disclosure of the client's consent and understanding. You can't really detail too much with regard to the client being provided appropriate documentation and information about costs and disclosures, and always be mindful, of course, of whether that information needs to be put into another language, for example, if English is a second language or it needs to be interpreted or translated. And what do you do if there is an elderly client or capacity is an issue? So, of course, be mindful of all those flashing lights and obtain guidance from more experienced practitioners if required. Finally, on this part, it's a simple but effective message I found about a lawyer's creed. I'm sure it comes from America. Mind your manners, tell the truth, and know the law. I know it's simple, but it sort of all wraps up in what we've been talking about in this professionalism and personal identity and professional identity, and how that links in with our obligations as lawyers. It's a great profession, guys. Enjoy it, but we do have a high bar to maintain, and it's really, I think, to not only our advantage but to the profession's um, image and reputation. And that's the end of this lecture. Thank you.